Hello, my name is Raven Willis, and I am a trademarks and business contracts attorney located right outside of Fort Worth, Texas. I hope you enjoy this video. Thank you so much for clicking on it. It's got lots of good information about the basics of trademarking. So if you need any help, then feel free to contact me. My information is below, and enjoy. So the first item I want to talk about is just generally, what is a trademark? So a trademark is a slogan or a name or a word, or it could be a series of colors, anything that associates a certain product or a certain service with your particular brand. So notice that I didn't say that it was your business name. It could be your business name, but it doesn't necessarily have to be your business name. But it's a word. Usually, it's a stronger word, but it's a word, a slogan, or a design, so that when a customer sees that, they can automatically associate that with your brand. So, what are trademark laws? Why is it important? Well, generally, the law encourages businesses to be innovative and to create products and to make those products basically the best that you can. And so you want those products to be associated with a certain brand. And the government doesn't like when somebody else tries to encroach upon the hard work that another business has done to build up this brand. So it's called unfair competition. So to kind of ward that off, they created these trademark laws. So that way, when a business has put a lot of investment into creating a product or creating a service for their customers, that the government will help to protect that. And so it allows you to have that trademark to ward off those unfair competitors who would want to essentially hitch their wagon to all of your hard work and create a subpar product or a subpar service, but then use your good name to associate with it and then kind of drag your name down because that product is not up to snuff and up to par. And also they didn't invest all of that money into creating that brand. So that's not really fair. So that's kind of just a general background on why trademark laws even, exist. So generally the laws protect strong marks versus weak marks. We'll go into a little bit more detail about kind of what is a strong mark and what is a weak mark, but something that's very general and that is descriptive is going to be considered more of a weak mark. Something that has absolutely nothing to do with that product or service, but it could be something that you've made up. That's more along the strong mark. So the government is more protective, or helps you to be more protective of a strong mark, something that you've created that has nothing to do with the product or service, but that you've marketed and now you've associated with that word that previously was kind of not the same, but now you've marketed it and you've fused it with that product and you've built it up. That's going to be strong, and the government's going to be more protective of that. So next up, we're going to talk a little bit about the ownership. So the trademark law is very interesting in that a lot of people think that you have to actually register your trademark in order for it to be yours. Well, that couldn't be further from the truth. Actually, once you start using a valid trademark, the keyword is valid. Once you start using the valid trademark, that trademark becomes yours. Registering it helps strengthen your rights, and it makes it a little bit easier down the road in case you have to dispute it. And also it'll save you some money because it proves up a lot of points up front versus waiting down the line to when you're disputing it and you're spending a lot of money on attorney's fees. It does save you time, and it definitely is worth registering if you have the money and the resources to do that. But again, you don't have to. Once you start using, again, a valid trademark, it is yours. So don't get that confused, going forward, thinking that just because you haven't registered it, it's not yours. Once you create a valid trademark, just stick that superscript TM at the end of it to put everybody on notice that, hey, this is my trademark. We'll get into it a little bit more, but make sure that it's valid by doing a thorough search from different databases and the internet and so on and so forth, because you want to find people who may not have registered their trademark, but who, again, are valid owners of it. And so you want to make sure that your trademark doesn't, infringe on their rights. So that's the ownership of it. So also, the laws want to prevent, like I said, customer confusion. When you create a trademark for yourself, make sure that it's not going to get confused with a similar trademark. A lot of people think that if you spell a word differently, then, okay, therefore it's automatically, sufficient. That's a sufficient difference to differentiate your slogan or your trademark from somebody else's. And that's not necessarily true. If it sounds the same, even if it's spelled differently, that could be infringing on somebody else's trademark. Like, let's just say Nike, if you spell it Nihkee, but you pronounce it the same, that can lead to customer confusion, even though it looks different. So you want to always make sure that it's different so it doesn't cause that confusion. Another important thing to note is that even if you have a trademark that is identical to someone else's trademark, if it's for a completely different product, then that's probably okay. Like, for instance, I've used this example before, but Eclipse. I remember back in the early 2000s, it seemed like everything that came out had the trademark Eclipse, like Eclipse gum, Eclipse the car. Notice that those are two completely separate products. There is no chance of confusion. So the word Eclipse could be registered for each of those products because they're in two completely different groups. However, if there was an Eclipse candy, then that probably isn't going to fly because that's too similarly situated to Eclipse gum. So there probably is not the chance of customer confusion, even though the trademark does sound and it reads and it is exactly the same. But again, because it's for two different products, people aren't probably going to get confused by it. Now, the exception to this rule is famous trademarks. You cannot, no matter if it's for a different group or anything, if it's a really famous trademark, you cannot use it no matter what. McDonald's is a great example. Everybody knows McDonald's. McDonald's is in the business of fast food and creating hamburgers and French fries that I eat too much, and those frappes that are just crazy delicious. So McDonald's makes those. You cannot use McDonald's trademark, meaning the double arches, for anything. It cannot be associated with a TV or a video game or a couch or carpeting. It cannot be associated, and those are things that I'm actually looking at right now. So you cannot use the word McDonald's for any of that because McDonald's is a famous brand. And so even though it's for something completely different, you still can't use it because, again, that's the exception. It's a famous brand. So because it's so famous, even if it is in a different category, it probably would cause some sort of confusion. So I think it probably goes back to, the previous point of the customer confusion. So one other thing about trademarking laws that is of very great importance, in my opinion, is that it is self-policing. You have to keep on top of who is using trademarks that could be too similar to your own. The government is not out there looking for these things. There's nobody else that's going to bring it up. If you're not going to police it yourself and be diligent about protecting your trademark, there is nobody out there that's going to do that for you. And the sad part is that if somebody has been using, a particular trademark, that it could be identical to yours, it could be just too close to yours. But if somebody is using it for a certain amount of time, you can't bring suit against them for doing that. You pretty much lose your right to come after that person. there's a couple of different legal theories, but the one that comes to mind is latches, meaning if you sleep on your rights for too long, then you just lose your right to go after that person. So please make sure that you have a procedure in place to monitor your trademark. And if you find someone who is using a mark that's too similar and that's in a very similar group, then you have to go after that person and you've got to demand that they cease and desist. Again, it's self-policing. If you're not going to do it, nobody's going to do it for you. And then if you don't do it at all, then you're going to lose your ability to go after them. So let's talk a little bit about the different registers. So the first register is the principal register, and this one is definitely the most important. They have also a supplemental register, but that one is for weaker marks and things like that, and I'll talk a little bit more about that. But for the registers, for both of them, they include information about your trademark, like the trademark itself, who the owners are, the dates that they're registered, what the types of goods and services that the trademarks are associated with, and other information like, how the marks are described, how to, like if it's a design, then it has to describe how the marks are actually described. Now, of the two, the principal register and the supplemental register, like I said, the principal register is definitely the way to go because it offers the strongest protections. So to qualify for the principal register, there's a few criteria. So one of them is the trademark has to be actually being used in commerce. Now, it has to be used in commerce, but also the commerce has to be across state lines. The most important takeaway from that isn't so much the across state lines, although both are important, but it has to be in use. The trademark has to be in current use. Now, there's a way that you can start the registration process and basically put on the application that you intend to use it, but the trademark is never going to be actually registered until you are using it. Fortunately or unfortunately, the trademarking process is so long, it's at least a year, that normally even if you register it as you intend to use it, by the time the registration process kind of comes around and they need more information, you'll probably using it. So that's why it's a good idea, if you are 100% sure that you're going to be using it, then to go ahead and register it. But during the registration process, it may not come up that you're using the trademark across state lines, like if you're an e-commerce business. But if someone does challenge it later and they find out that, hey, you're only using it within your state, and you're not using it again across state lines with customers in other states, then that federal registration is going to become invalid. So it is still important that you understand that it does need to be across state lines. So that's the first criteria. The second one is it has to be sufficiently distinctive. It can't be something that's very general and very weak, like I talked about earlier. If you have, say, a subscription box and it's for cosmetics, and you just call it the cosmetic subscription box, that's too weak. It's too descriptive. It just describes the underlying product. It needs to be something that's, like I said, memorable. Like if you called it Wally Kazam's, cosmetics or something like that, the Wally Kazam. I was just watching that with my 3-year-old. So if you called it that, then maybe that would be good enough to be, sufficiently distinctive. So again, the mark can't be similar, confusingly similar. We talked about that. That's another criteria for it to be registered. And the mark cannot be in one of the categories that Congress has deemed that it's that has deemed that it's off limits. Like, for instance, you cannot trademark the name of someone who's living. Like, you cannot trademark Donald Trump. That probably cannot be included in your trademark because he's living, unless you have the permission of them. And even still, the government doesn't like you to trademark a name, because there could be another person named Donald Trump out there living, and then they wouldn't be able to use their name associated with their product. So the government, again, it kind of doesn't really like that. So it's a good idea to stay away from that a little bit. And also, you cannot use the term U.S., United States. Stay away from things that kind of have governmental agencies or anything like that included in them. Also, another criteria is the trademark should not consist of a geographical name. Again, that's still a little bit too general, because the government doesn't want to keep people from being able to use common words, names of places and things like that in products. They don't want to prohibit that type of use. So again, stay away from things that have, a city in the name or a state. You're not going to be able to trademark that, or you're at least not going to be able to register it. And of course, it's probably not going to be a valid trademark either. Now let's talk about some of the benefits of registering your trademark with the principal register. What it does is it basically puts other companies, other people on notice all across the U.S. that this mark is unavailable. So you get to put that superscript R with the circle around it, again, which puts everybody in notice that, hey, it's registered, it's mine, hands off, don't touch it. So, and also what it does, and this is, I think, the most important piece of it, is there's the legal presumption that whoever has registered that mark is the actual owner. So if anyone then challenges your trademark, they're the ones that have the burden of proof. And why this is important is whoever has the burden of proof, they're going to spend the lion's share in legal fees, because their lawyer is going to have to gather all of this evidence to overcome the presumption that the registrant is the actual owner of that trademark. So it saves you, like I said earlier, it saves quite a bit of money. And again, you're not spending the time, the resources trying to mount up an attack, essentially, that the trademark is not yours. I guess it would be a defense that the trademark isn't yours. It would be the other party who would have to expend all of those resources, time, legal fees, and all that to try to, like I said, mount that attack against you. And that's pretty significant because, as we all know, lawyers are very, very expensive. So all of these benefits together essentially make winning a lawsuit a lot easier for the person who has registered their trademark. So let's talk about the supplemental register. So what that is basically is for marks that really didn't quite cut the mustard to be on the principal register. They're not strong enough for whatever reason, but they are strong enough to be on the supplemental register. And it doesn't offer a lot of legal protection. Actually, it doesn't offer a whole lot more than just putting the TM superscript on your trademark. But what it does is, because it is listed in the register, that when people do a search, your trademark will come up. So it will probably end up dissuading someone who has a mark that's similar to yours from using it, and it's easier to find. So that right there, in my opinion, is enough to warrant registering your trademark on the supplemental register if you still cannot register your mark on the principal register. It does do a very good job of putting others on notice. So the final type of register is the state register, depending on where you're doing business, where you're located at. Earlier, I had said one of the qualifications to register your mark on the principal register is that you have to be doing business across state lines. And in essence, you have to have like an e-commerce or something where you're shipping your product or your services to someone, a customer in another state, or you're providing something to someone in another state. that's when the federal laws kick in and you can register your mark on the Federal Register. But what if you have, say, a dental practice and you're located in, where I am, I live in Keller, Texas, and you don't provide any services to anyone outside of the state of Texas. Actually, you don't provide any services to anyone outside of your city. What do you do then? You still obviously want to protect your brand, but that would not be eligible to be registered in the federal register, in the principal register. What you can do then, or what you should do, is register your mark in your state register. And each state has one. It provides you the protections of your mark, but on a state level. So what it does not do is it doesn't keep other people from other states from using it because, again, they're in a completely different state. However, it does protect you from others in your own state, in your own city, or wherever you're doing business from using that mark. Let's talk about now business names and trademarks. I am in several groups on Facebook, and this topic comes up quite a bit because what folks do, I've noticed, and I've been guilty of this too. I mean, hey, I'm a lawyer, but I make mistakes too. But what a lot of people do is they go ahead and they create their business name and they don't first do a search to make sure that that business name isn't already trademarked in some way, shape, or form. So let me talk a little bit about when a business name becomes a trademark. So automatically, a business name is not automatically a trademark. For a business name to be a trademark, it has to meet all of those qualifications that we talked about before. It has to be distinctive. It cannot cause customer confusion. It can't be a famous trademark, things like that. So your business name, in order for it to be a trademark, has to meet that criteria. And a lot of business names actually do meet that criteria, but some business names, even though they meet that criteria, they are actually encroaching upon somebody else's trademark. So what do you do then? So what happens if you create a business and it's already basically trademarked, you are prohibited from marketing your business using your business name. So the only place that you can put your business name will be essentially on your checks. It can be on your credit cards, the account. It can be on your official documentation, but you cannot put it on your website. You have to come up with a completely different name, a trade name or a DBA or something like that. You cannot market with it at all. It can't be in your emails. It cannot be in your header, your footer, nowhere. Because once you actually start marketing your goods or your services with your business name, if it encroaches or it infringes on somebody else's trademark, they can come after you for that trademark infringement. So it's a very, very good idea. Before you create your business name, make sure you do a search and you try to find any trademark that is in existence that could be too close to what you want to have your name as. It will save you a whole lot of work. Now, again, you still can use it, but you just can't market it. And also, one other method maybe to fix it is just change the name. And that's expensive and it requires a lot of time to go through the process of changing it, with your state and with the IRS and all that, your business tax ID, everything like that. So the moral of the story is do a quick search first. Well, thank you so much, guys, for sitting through this presentation. Again, thanks for watching my video. If you have any questions, feel free to email me at my contact information below. Again, my name is Raven Willis, and I appreciate your time.